May please, Lordships. Lordship, I beg to mention hearing item number 12, Lordship. May I pray that this matter be listed after 2 weeks, Lordship. Lordship, on behalf of my senior Azo, the blue muffler, Lordship.
मेरा फोन हो गया
Lordships, I also beg to mention item number 15, Lordship. Hearing item number 15. Let this matter be listed after 3 weeks, Lordship. Yes. Lordship. Lordship, on behalf of Takakichu, Lordship, I beg to mention hearing item number 16. Lordship, item number 16. Let this matter be listed after a week, Lordship. On behalf of Takakichu, respondent number 17. 17, Lordship. A week, Lordship. Obliged, Lordship.
May I please, Lordships? Lordships, I beg to mention hearing item 10 and 11. Lordship, here I'm appearing on behalf of appellant, Council Appeal Sanctum, Lordship. The council is indisposed. Can this matter come up after 3 weeks, Lordship? Ali Bozcom, Lordship. Three weeks, Lordship. Obliged, Lordship.
May it please your Lordships. Your Lordship, I beg to mention here in item number 14. Yes, I pray this matter be listed after 3 weeks. Three weeks, your Lordship. Highly obliged.
थोड़ा मैसेज है
May I please, your Lordship? I beg to mention item number 18 and 19. Your Lordship, my senior has some difficulties today. So if the matter may be fixed after a week and so long.
Each one, the living council. That's something.
One week, your Lordship. Much obliged.
For motion, item number 1.
May I please, your Lordship. Your Lordship, at the time of filing this instant petition, inadvertently I did not include some necessary parties. So yes. No, yes, but yes.
No additional affidavit has been filed.
Yes, Lordship. No, inadvertently I did not include some necessary parties and then some paragraph. So I may be allowed to withdraw with the liberty to file afresh. To Shidamjan.
He has instructions to withdraw the petition. He will leave it to the petition. The petition is allowed. He will withdraw. He will leave it to the petition.
Much.
In our appears for the government, is supposed to be responded.
Much obliged.
For admission, item numbers 2 to 4.
Your Lordship, if the matter may come up after a week Appellant, your,
Yes.
You're also for the respondent.
Yes, Lord.
You're mentioning on the level.
the appellant,
Okay.
Lord.
On the prayer of.
Lordship, if it is convenient to my learned friend, then let it be up to 2 weeks. I'm still working on the query which Lordships has put on me.
Okay. On the prayer of. You're doing that.
and solo.
And so, you're also for the. To the appeal.
Yes, your lordship.
These are the gifts after 2 weeks.
Much obliged.
For admission, item number 5.
Yeah.
On the last occasion, Lordships, on 23rd April, a pointed query was made by me whether it will be appropriate to withdraw and file a review. So I took 1 week time to get instructions from a client. In the meantime, I have also given a serious thought whether it will be appropriate to withdraw the present appeal and file a review application. But then to file a review, the scope to consider this aspect of the matter, considering the points which we have raised in the appeal, will not be cured by way of filing a review. So I have decided to press the writ appeal rather than withdrawing and then filing a review application. Because Lordships are well aware that in a review application, the scope is very, very limited. The other day I was also pointing out, I have also mentioned that it is as good as asking the moon in a review application. The scopes are very limited. And keeping in view of the points which we have raised, those are the points to be decided by the appellate court. And the basic difference between the earlier petition and the present petitions were different actually. But then during the course of hearing, the counsel representing the present appellants, who were the respondents in the writ petition, have made a concession. That has caused Lordship.
This concession on facts or concession on law. That has to be done with this concession on law. That concession will not stand.
Lordship, in that regard, I would like to make 2 submissions. With regard to the facts, that is one aspect. And with regard to the law, a point was raised during the hearing of the earlier, other writ petitions with regard to the maintainability of the writ petition. Maintainability of the writ petition is also a question of law. It also mixed with the facts as well. If the concession is made on the issue of law, on the question of law, then that will be of no consequence because law will take its own course. So even if the council made the concession on the question of law, then those are immaterial. Law has to take its own course. That is one aspect. That is on the question of law. I have nothing to argue on that because it is a point of law. Law will take its own course. But during the hearing, a submission was made, and it was one of the contentions of the respondents, especially the state respondents, that there is a basic distinction between the illegal appointment and irregular appointment. And the petitioner's case is founded on the case that this is illegal appointment because advertisement has not been issued, which is contemplated in terms of the order dated 7/7/1976. This is an order issued by the government where for any appointment, advertisement has to be issued. That was the contention of the writ petitioner. That is the main point of contention. Now, in that regard, a submission was made by the learned advocate general that, look, this is just executive instructions only. Therefore, by not following the executive instructions, it will not make any difference. But so far as constables are concerned, it is governed by Rule 20 of the Nagaland Police Manual, Volume 3. That is the concession and submission made on behalf of the state by the Learned Advocate General. Lordships was the Additional Advocate General for a long time. Lordship is well aware about all this. The concession made by the Learned Advocate General and the concession made by Additional Advocate General. There is a C difference also. And any concession, I'm coming to that. The Learned Advocate General has made a concession in the court. So court is bound to accept the concessions made on behalf of the Learned Advocate General. During the hearing, the Learned Advocate General has made a mention that, look, giving in view of all these developments, the state has given a serious thought on it, and we found that the appointments are irregular. Therefore, we have taken a decision to go for fresh recruitment. However, some level of relaxation may be shown. That was the concession made by the Learned Advocate General. And to that effect, on 20th of August 2024, this Honorable Court was pleased to allow the state to file an additional affidavit. To what extent you want to make a concession? So affidavit was filed. This Honorable Court has also, Learned Single Judge has allowed to file affidavit, and accordingly affidavit has been filed. And then in what manner the relaxation has to be met, all these things have been met. So, however, at the time of hearing, on 20th August, that aspect of the matter was not taken into consideration on the ground that if I grant relaxation, as mentioned in the affidavit, it will amount to relaxing the basic qualifications, which is not permissible, giving in view of the law laid down in Ajoi Debarma case and Danmoy Nath's case. But Ajoi Debarma's case and Danmoy Nath's case are related. In fact, the Honorable Apex Court has dealt with more detail in Danmoy Nath's case. This is a case Lordships will appreciate with regard to the appointment of teachers, where more than 10,000 teachers were appointed. Yes, Tribura case, Lordships. Now, there are two provisions, statutory provisions. One, NCTE Act of 1993, which has clearly barred for any relaxation. One. Two, right of education. Right to Education Act 2009. There also the UGC has issued notifications after notification, and the act itself is very clear that there can be no relaxation on basic educational qualification. Why? Because the teachers are the menders for the leaders of the nation tomorrow. Therefore, there should be no relaxation with regard to the educational qualification. So I would also agree to that, because that is with regard to the education. So there was a clear stipulation in the provisions that there can be no relaxation. The Learned Single Judge, by relying on these two judgments, has not granted the relaxation also. But the Learned Single Judge, with due respect, yes, yes, that is pertaining to constables.
This is SI.
Yes, this is his side. But
So they have the requisite qualification.
yes, Lordship, all of them has. Now, another case was relied that is of 2003, the Pankaj. No, not Pankaj, Suresh Kumar. That is a case from Bihar, where 1,600 constables were appointed in the same manner that has been done in our case. I'm making reference to 935 only for the time being, because our case has been relied on this case. Same, there is no difference. That is why I'm referring to the constable's case. So my learned friend has referred to that case, that look, in a similar case, the Honorable Apex Court has interfered with. But interestingly, in that Suresh Kumar's case, relaxation was given. All relaxation was given with regard to physical qualification, eligibility criteria, relaxation has been given. Only thing is that the appointments were quashed and set aside and directed the state to advertise the post afresh. But relaxation was given. And another very interesting observation was made in that particular case was not only relaxation of the educational qualifications, even the service benefits were given to those persons who were working but quashed and set aside by the order of the court, but they were allowed to appear in the free selection process. They were allowed. And an observation was made by the Apex Court that if these persons who appear in the pursuant to the direction, pursuant to the free selection, if they were selected, they will be given all the seniority benefit, all the service benefits, and they will not be required to go for fresh basic training again. Because this is a case of the police service. So any person who is selected has to undergo basic training. That is about 1 year. Now, so far as the present appellants are concerned, we are sub-inspectors and assistant sub-inspectors. And we are trained, not in the Kohima, we are trained in NIFA. Lord Chief is well aware about NIFA, what type of trainings are imparted, and then it is under Ministry of Home Affairs. And on completion of your training, they are made to swear under the Constitution. So that aspect of the matter, suppose, yes, no doubt, our appointment has been quashed and then allowed us to sit for the next exam. Suppose we appeared pursuant to the free selection and some of us selected. I'm sure not all will be selected, but some of us, suppose, if we are selected pursuant to the free selection process, can we be subjected to another training and another swearing under the Constitution? That will be double swearing. That is why, Lordship, my appointment has already gone. Now, if I sit for the exam and if I'm selected in the free selection process, can I be again go to the same training institute and train for 1 year and again swear in the Constitution? Those aspects of the matters.
You are actually like participating in a high jump.
Another aspect,
You are
Lordship.
participating in a high jump. Instead of jumping the bar, you have crawled and then you have actually crossed the bar.
Lordship, from day one, that is an admitted fact that from day one, Lordship, we are admitting the fact that yes, Lordship, actually, it is like this. My learned friend, Mr. T.B. Jamir, has submitted letter of absence. 1.
And TV driver is presenting.
He is representing PHQ, police respondent. And in the supplementary cost list, my learned friend L.T. Sangram has been reflected, his name has been reflected, leave of absence. So in all probability, I was under the impression that two respondents has availed leave. So,
Yes.
no, he is here now. But before entering to the court, I was under the impression that since two counsels has already availed leave, who are main respondents, matter may not be taken up today. But I was prepared on the ground in taking, in view of the order passed by this honorable court on the last occasion. Because if I seek any adjournment, then definitely the consequences will be serious. Therefore, on my own, I should not seek adjournment. And this honorable court order and passed on the last occasion is very clear that on my ground, if adjournment is sought for, then the respondents were given it liberty to press for vacating the status quo order. But if it is other grounds, the matter is not taken up or matter is adjourned on different ground. Exactly, Lordship. Exactly, Lordship. Application has to be filed, if that is the case. But then since I've been put under a difficult, critical situation, I have accepted that and then, yes. So if your Lordship places, then I can proceed.
Your Lordships, I am appearing on behalf of my senior TV Jamir for respondent 2 to 5. As per the instruction that I've received from my senior, I'm supposed to rely on the submissions made by the learned EAG. Yes, Your Lordships. So can we proceed?
If your Lordship places, then okay. Otherwise, we can take it up in the next week.
Lordship,
In
I-
presence of Mr. TV Jamir also. That will be more reasonable, Lordship. Otherwise, subsequently, he may have some grievance also that I have
My
filed letter
lord,
of
I
absence.
lost my nephew day before yesterday from. My nephew expired. Then thereafter, I accompanied the mortal remain. I reached last night, and I'll be away. Next week, I may not be able to attend. If after 2 weeks, it can be possible.
Yes, madam, we are sorry to postpone, but I think we may have to postpone.
I leave to this honorable court's discretion. It will be always one way or the other.
There are certain things which are beyond our control. Nobody writes an application to face difficulty, and then bereavement also we cannot stop. There are some genuine grounds where adjournment matters are deferred also. Over the years, I have been experiencing that I'm fully prepared with the case, but then due to one or the other reason, the matter had to be deferred on many occasions, Lordships. And
Yes, ma'am.
It depends on you, whether you're ready,
I'm ready, ma'am.
you're ready.
Okay.
Lordship.
Yes.
The present appeal has been preferred, Lordships, against the order dated 26/9/2024.
Yes, let us go to the operating portion of the order, which is the case.
It starts from page 396. It's operative portion. 396. This order has been passed in a similar line with that of the order dated 29/20/24, passed in 11 cases. Mr. Lordship, got it? But in substance, Lordship, our appointment has been quashed and the respondents were directed to go for free selection process within a period of 6 months and to complete that process by a subsequent order that has been extended, Lordship. Now, in the event of the free selection process, the petitioners, the respondents were allowed to participate in the free selection process and no relaxation has been granted except the age relaxation. So that is the sums and substance of the order. And then till that time, the respondents, the appellants should be allowed to remain in the service. This observation has been based, Lordship, pursuant to the order passed in the other cases. Lordship will find in the page 395, paragraph 14. Paragraph 14, Lordship, 395. May I read, Lordship? As no distinguishable feature is found between the facts and circumstances obtaining in the present writ petition and the facts and circumstances obtaining in the patch-up writ petitions, that is WPC number so and so and so and so. This court is of the considered view that the observation and directions made in paragraph 36 of the common judgment and order passed in the patch-up writ petitions also applicable to the case in hand. Such view of this court is also fortified from the submission of the learned counsels for the parties, including the learned counsel appearing for the state respondent authorities who are at consensus at item on the facts that the appointments of the respondent number 6 to 45 were made in a similar manner like 935 number of appointments in the post of constables in Nagaland Police. Challenge in the patch-up writ petitions, that is writ petition number so and so, which are shown, which are disposed of by a common judgment and order dated 29/20/24 with the observations and directions quoted above. So all these directions have been based in the earlier order, which has been passed on 29/20/24.
That is 29/20/24 is to do with the constable.
Yes. That is in respect of the constables. Now, during the hearing, as I was mentioning before, a query was made by this honorable court, by the learned single judge in the present proceeding, that whether that judgment will cover this case as well. So the learned additional advocate general has made a concession that yes, there is no distinguishable features between that case and the present case. Therefore, that case will cover our case also. And affidavit, a common affidavit has been filed in that case, in the constable's case, that will also cover our case, this present case. That was the categorical submission made by the learned advocate general. And the learned single judge proceeded on the basis of the submissions made by the learned advocate general. Now here, at the time of hearing the present case, which was heard after 6 days, the learned additional advocate general represented the state and the private respondents were same, the same counsels. So here there is also a basic distinction on the submissions, the concessions made by the learned advocate general in the constable case and the counsel who has represented in the sub-inspector's case, that is the present case. So there is a difference. Now, in our case, that is in respect of the WPC 317, that is sub-inspector's case, affidavit has not been filed. No affidavit in opposition filed. Yes, no doubt, the counsel has represented the respondents. And there was serious communication gap between the counsel and the client while conducting this case. That is the reason why the respondents were compelled to file a review application where out of the 48 respondents, 2 respondents who were recruited through open advertisement were also implemented as party respondent. Petitioner did not know that these 2 persons were selected on the basis of an open advertisement and they were recruited.
That review petition was filed only by these 2 persons.
Yes. No, I'm trying to project
No, no,
that
no.
there was
I
serious
also
communication.
want to understand.
Yes.
I'm sorry, we also want to
Correct.
understand the case.
I'm referring to that to show that there was serious communication gap between the client and the counsel. That is one of the manifestations where there was serious communication gap. A person who has been implemented in a case as respondent, who was appointed on the basis of a open advertisement. Statement was made in the writ petition that they were all appointed illegally by picture method without any advertisement. That was the categorical statement made in the writ petition. And the person who has been appointed, 2 persons who were appointed pursuant to an advertisement were also not aware that, oh, such a statement has been made. That means the 2 persons who were appointed on the basis of an advertisement were not aware how the case was contested.
But the chapter is closed with the review. So far as those 2 persons are concerned,
no.
the chapter is closed. with
Yes,
filing a review.
that is already resolved. But what I'm trying to project is there was serious communication gap between the client and the counsel. That is how the affidavit in opposition could not be filed by the counsel.
In your
And-
paragraph, which paragraph you have stated that as submission? Which paragraph? In your appeal?
Paragraph 5.
Which appeal? Which paragraph? Where have you stated, Mr. CQ,
Regarding
regarding your submission made now?
serious communication gap.
Ah,
Lordship, yes. Kindly come to the review.
no, your appeal? Whether in your appeal you have taken that.
In my appeal, yes, yes. I have
Yes,
taken-
kindly,
I have
kindly
taken-
come to the appeal.
Yes. Ground P, Lordship.
Ground B.
Yes. Page 18.
What about your statement that there was miscommunication?
In the review, Lordship, can we see?
Not in the review, that is disposed. That is disposed, correct?
Yes, but then the council, how they have, it was reviewed. Can you come to the review? It's 374. Page 374. And then relevant is paragraph, page 377. This will have an important bearing, Lordship. Kindly come to page 377.
Which para?
Para 8. I will refer to only two paragraphs. May I read, Lordship?
Yes.
Mr. Pungoner, learned counsel for the review petitioner's hearing, has submitted that there was some kind of miscommunication between him and his client. That is the respondent number 44 and the respondent number 45. He has submitted that two, it was represented to him that the appointments of the respondent number 44 and respondent number 45 were preceded by an advertisement and a recruitment process. No document supporting such facts was furnished to him at a time prior to the date of hearing. As a result, he could not represent on the date of hearing that the fact situation relating to the respondent number 44 and respondent number 45, that is, the two review petitioners hearing were different from fact situation obtaining as regards the appointment of the other private respondents, that is, the respondent number 62, respondent number 43 in the writ petition number so and so, and kindly come to next page, page 379, paragraph 9.2. 9.2, Lordship.
Hmm.
9.2, last paragraph, Lordship. Page 379. Mr. Jamir has further submitted that written instructions were sent from the official respondents to the government advocate who represented the respondent number 2 to 5 earlier, wherein it was mentioned that appointment of respondent number 44 and respondent number 45 was preceded by an advertisement and due selection process, as the said written instructions were not handed over to him at the time of hearing over the brief to represent the respondent number 2 to 5 in the writ petition number 317 of 2023. He could not place and apprise the court about the said instructions at the time of hearing of the writ petition number so and so. In essence, it was due to miscommunication. He could not place proper instructions at the time of hearing. And kindly come to page 14, Lordship.
Page?
Page 14 of the appeal memo. Ground, facts 9. Must it, sir? You don't say. Yeah, let's see.
Para? Nine?
Para 9, Roman 9. May I read, Lord? That the facts and circumstances of the WPC number 317 of 2023 and the facts and circumstances in the page of writ petitions are not similar and identical, although the question of law with regard to the non-advertisement to the post is similar. The difference of facts and circumstances of WPC number 317 of 2023, that is our case, present case, from WPC number 189 of 2022 to WPC number 199 of 2022 is projected herein below. 1. Respondent number 6 to 45 in WPC number 317 of 2023 were appointed as sub-inspectors and assistant sub-inspector by the competent authority in terms of the Nagaland Police Manual, and they have successfully completed their training at Northeastern Police Academy Amso Parapani, Meghalaya in the year 2021. The Training Academy of Sub-Inspector and Assistant Sub-Inspector is under the Ministry of Home Affairs, whereas the police constables under the state government. Moreover, in the page of writ petitions aforementioned are the private respondents, where the police constables whose nature of appointment eligibility criteria are different. So there are a lot of difference between the constables and the sub-inspectors, but a concession was made that these are same, in essence, all are same. So the judgment which was passed on 20th September 2024 will cover our case as well. That was the concession made where the whole problem arose out of that, Lordship, because affidavit in opposition has not been filed. Had we were allowed to file affidavit in opposition, we could have bring so many facts, Lordship. Even the writ petition was not maintainable. All those points could have raised. So, Lordship, without
But what would be your case on the question of law? Because we are concerned with law, not facts.
Lordships, I will try to refer to few Supreme Court judgments where the cases were allowed, where there has been lapses on the part of the counsel who is conducting the case. So in 1981, the Apex Court has passed a very important order, and that order has not been superseded till date, not overall till date. So I would like to refer to those cases also. That is also a law laid down by the Supreme Court. So had the appellants were allowed to file affidavit in opposition, then we could have projected all these facts, and it may be dismissed ultimately, but we have to accept the law. But then we are feeling deprived that for not filing the affidavit, we are facing this kind of serious consequences. The fact remains that no affidavit in opposition has been filed in the writ petition, in spite of the fact that the clients were under the impression that the affidavit in opposition has been filed by the counsel. Yeah, yeah. And again, Lordship, kindly come to page 16. This is the continuation of paragraph Roman 3. Lordship, bear with me. Let me just read out from para 2, page 15. Most of the private respondents in WPC 317 of 2023 are entrusted, appointed
You are
as
reading which page?
page 15, Roman 2, the second from the top, Lordship. Roman 2. Most of the private respondents in WPC 317 of 2023 are entrusted and appointed as investigating officer, branch ICs, crime ICs, and second OCs in various criminal cases investigated by them, which are pending before the criminal courts, and by filing charges in those criminal cases. Whereas those private respondents in the page of writ petitions are constables whose works and duties are totally different. And here, Lordship, I would just like to have a pause. There are about 604 charge-sheeted cases where the present appellants are the IOs. And there are 114 cases which are pending where the present appellants are the IOs. All these cases will be prejudiced. Roman 3, Lordships. Out of 40 private respondents, there are 5 women inspectors and assistant inspectors, and some now family holders. And almost all the private respondents have already crossed the age of 30 years. Considering the present appellants advanced in age to compete with the fresh candidates who would be younger in age, some relaxation in physical fitness would have been considered by the court for the serving personnels. Moreover, in view of the services rendered and experience gained during their service, who are assigned as branch ICs, crime ICs, second OCs, and IOs in various criminal cases. Preference to such experience gained by the appellants who are continuing in service would have been given.
Mr.
16.
Mr. Jamir, what is the perversity of law committed by the learned single judge? We are mainly confined to
Lordship,
that. What
kindly,
is the perversity of law?
kindly come to page 16. However, due to non-filing of affidavit by the respondents, those facts were not projected, which led to passing of the judgment and order dated 26/9/2024. The appellants herein are therefore assailing the impugned judgment and order limited to para 15 Roman 5, whereby the learned single judge have denied the concession relaxation sought by the state government.
Mr.
in
Jamir,
the
Mr.
service.
Jamir,
Lordship.
all these are facts which you are bringing in support of your case. But we are concerned about the perversity of law committed by
Lordship,
the learned single
I,
judge.
I fully agree with the Lordship, but to apply the law, first, it should be based on the facts to apply a similar law, whether the facts are similar or not.
The fact
is
is that
important.
the fact is that the law here is that the fact is that whether you have actually gone through the process of selection.
Lordship, there was no advertisement. We are admitting from the very beginning
So
that
there is
yes.
violation of a constitutional scheme. How can we cure
But
that?
Lordships are well aware, in Omar DB's case, in paragraph 53, the distinction has been made between the irregular appointment and irregular appointment.
Right.
Our appointment, we are all eligible and all qualified. But certain procedures were not followed. I would like to make a
If we have to
distinction
go
here
by
also.
Uma Devi's case, you should have been appointed in the year 1996 or prior to that. That's all,
Exactly, Lord.
nothing more.
Exactly.
No. Now, the basic distinction. The reliance made by the petitioner is basing on notification of 7/7/1976. That is command to all. In respect of sub-inspectors, a notification has been issued by the police headquarters in 2004, where some amount of relaxation has been granted to the for appointment of sub-inspectors because of the fact that police department is such a department where there may be emergency law and order problem. The strength of the police personnel may not be adequate enough to
Mr.
resolve those problems.
Whether the requirement was meant only for this and not for others.
No,
Whether the
that is why.
whether the immediate requirement of service was meant only for this persons or it was also required for the other persons.
Lordship,
See, that is the.
I'm making submission about the police department. We are not concerned with the other department, but
No,
so far as
I am not talking about other department. Whether these persons were the only eligible persons to be recruited in this post, leaving aside the others.
no, that is why, Lordship, in the process of advertisement, there will be a long process. Entire detailed procedure will be followed.
Okay, okay.
But to meet the emerging situation, to cope up with the emergency situation, immediate appointments are required to be
Why
made.
not appoint them on exigency basis? Why give them
Therefore-
regular appointments
Therefore,
without advertisement?
the state respondents has made the appointments in the exigencies of service, but advertisement was not issued. So our appointment,
Mr. Jamir, you satisfy on low grounds. On low points,
Those
you
are the
kindly
low.
satisfy us.
okay, Lordship. Coming to the judgment,
Yes,
because we have two judgments with us.
yes, please.
If I am to rely on the subsequent judgment,
Correct.
there is no detailed observation. But in the earlier judgment, which was passed on 20th September 2024, the learned single judge has relied on 3-4 judgments so as to quash and set aside. And Lordship will find in the judgment and impugned judgment and order, of course, not in our case, but in the other case, illegal appointments have been used several times. And the reliance has been made in Pankaj Kumar's case. Pankaj Kumar's case is a case where appointments were made on the recommendation of the ministers, head of the department, or commissioners and secretaries like that. So random appointments have been made. There was a rule, service rule. By violating the service rule, of all those appointments were made in the assembly secretariat. Therefore, this honorable court has, the apex court held that these are all illegal appointments. Why illegal? Because rules have been violated. That is why it is illegal. And then no procedures have been followed. So it was called illegal. That is one of the cases. But in our case, the facts is little different. There is no provisions. There is no service rule frame.
What about the constitutional scheme?
No violation
What about Article
of
1416?
that constitutional scheme. I'll come later on.
That's
Now,
more important than the rules.
in Ajay Debarma's case, as I was mentioning, the rule itself do not permit for relaxation. So by relying on this, the order has been passed. But in the judgment, relaxation was given in that. In Pankaj Kumar's and Ajay Debarma's case, relaxation has been given. And Tanmoy Nath's case also, relaxation was given.
Relaxation of
Relaxation was not given because of the fact that there are two statutes, NCRT Act of 1993 and the Education, Right to Education Act of 2009. There the provision says that no relaxation should be given. Another interesting thing, during the course of argument, the learned advocate general made a concession in the court that if the court finds that the appointments were illegal, then no relaxation should be given. In our case, it was the brewer of the state that kindly grant us relaxation.
No, but the sum
That
and
was the-
substance,
So-
sum and substance same.
There is difference. If you are relying on one judgment, why not rely on all the findings?
Mr.
Why only Bismir?
Mr. Jamir.
That some
we-
portion is-
We agree with you on facts. We agree with you on facts. That you were not given the opportunity to file affidavit in opposition, that you were not given that opportunity to properly present your case. All these are facts supporting your case. But what does the law say is we have to go
And-
by that. Ultimately, we have to go by law.
Lordship, I will just refer one case. 1981,
Okay,
2 ACC,
just wait. 1981,
81, 2 ACC,
2 SSC.
788. This
Seven,
judgment
eight.
has not been overruled till date. I will read only one paragraph. Paragraph 3. Allow me to read this and then Lordship may apply your
Paragraph
mind. And
Para 3.
yes, has your Lordship got it?
Yes,
May I read?
please.
The disturbing feature of the case is that under our present adversary legal system, where the parties generally appear through their advocates, the obligation of the parties is to select his advocate, brief him, pay the fees demanded by him, and then trust the learned advocate to do the rest of the things. The party may be a villager or may belong to a rural area and may have no knowledge of the court's procedure. After engaging a lawyer, the party may remain supremely confident that the lawyer will look after his interests. At the time of the hearing of the appeal, the personal appearance of the party is not only not required, but hardly useful. Therefore, the party having done everything in his power to effectively participate in the proceedings can rest assured that he has neither to go to the High Court to require us to what is happening in the High Court with regard to his appeal, nor is he to act as a watchdog of the advocate that the letter appears in the matter when it is listed. It is no part of his job. Eki Shanghai stated that a practice has grown up in the High Court of Allahabad amongst the lawyers that they remain absent when they do not like a particular bench. Maybe we do not know. He is better informed in the matter. Ignorance in this behalf is our place. Even if we do not put our seal of imprimatur of the alleged practice by dismissing this matter, which may discourage such a tendency, or it not bring justice delivery system into disrepute? What is the fault of the party who have done everything in his power expected of him would suffer because of the default of his advocate? If we reject this appeal, as Mr. Akish Sanhai invited us to do, the only one who would suffer would not be the lawyer who did not appear, but the party whose interests he represented. The problem that agitated us is whether it is proper that the party should suffer for the inaction, deliberate omission, or misdemeanor of his agent. The answer obviously is in the negative. Maybe that the learned advocate absented himself deliberately or intentionally. We have no material for ascertaining that aspect of the matter. We say nothing more on that aspect of the matter. However, we cannot be a party to the innocent party suffering injustice merely because his chosen advocate defaulted. Therefore, we allow this appeal, set aside the order of the High Court put dismissing the appeal and refusing to recall that order. We direct that the appeal be restored to its original number in the High Court and be disposed of according to law. If there is any, I think that will not be that important for us. So-
Okay, we will apply our mind, but maybe I think.
I leave it to your lordship.
You are well aware about the category of decisions where it says that admission on law and admission on facts.
Lordship, that is, I do not dispute on
We
that
may
point.
apply our mind and apply those principles of law.
Lordship. But I would pray again and again that had affidavit in opposition were allowed to file. That aspect I have also met in my pleading also. In the facts.
Mr. Jamir, even if we allow you to file affidavit in opposition, how will you cure?
Lordship,
How will you cure the
You-
non-advertisement of the post?
we
How
are
will you cure that Article 14 and 16?
every day, lordships, we are dealing with the maintainability of the writ petition. This itself is also an issue of law, laid down by the Apex Court and also by the precedents of the different high courts, that whether the writ petition is maintainable or not,
No, Mr. Jamir,
although,
just
Lordship,
one thing. How do we overcome that situation? How do we overcome that situation where there is infraction of Article 14 and 16? How do we overcome that? You kindly assist us. So that if there is any way out, we will definitely help you because you are in service.
Lordship,
But unless you can explain, reasonably explain that the infraction, then I think we will have to go by law.
Lordships, if the writ petition is dismissed on the ground of maintainability, that problem will be overcome automatically. And to consider whether the writ petition is maintainable or not is also a question of law as well as facts. Lordships are well aware. So
You are also
if-
well aware, you are also well aware that if the appointment is illegal and in infraction of Article 14 and 16, then the question of giving, the question of violation of natural justice will not arise. You are well aware of that.
because for deciding a case, so many things are necessary, so many facts are equally important.
We appreciate it. We appreciate your submission.
Therefore, if the petitioner has played fraud in filing the writ petition, if I'm allowed to raise that at the time of hearing before the learned single
What is
judge.
that fraud at least? Not at the time of hearing, at least you should satisfy us because we are hearing this appeal. What is that fraud laid on by the petitioner in the writ petition? What is the fraud?
Lordship, in the writ petition, by filing affidavit, we can bring all this.
Okay. Any more citations, Mr. City?
No, Lordship, only on that point,
Yes,
that
we have.
for the lapses on the part of the council, why the litigant should be made to suffer. And I have tried to satisfy your Lordship
we
that look,
appreciate- we
there is serious communication kept between the council and the client. And this is a very modern aspect of the matter that may be
We have no-
examined by
we have-
this honorable
we'll
court.
examine, we'll
And
definitely
then
examine, we'll
we
definitely-
have not filed affidavit
and
also,
we will also apply our mind to the citations which you have referred.
Lordship.
We'll definitely. Yes, who is for the other parties? Let us see the parties first. Let us see the parties first. Yes, Mr. LT, you have also taken a very big risk to make submissions on behalf of Mr. Peter. Who are the respondents?
My lord,
Just wait, who are your respondents?
2 to 5, Your Lordship.
2 to 5.
Yes.
So since respondent number 2 to 5, since the senior counsel for the respondent number 2 to 5 is relying on your submission,
My
you
lord.
have a burden.
may it please your lordships. WBC number 317/2024 and 318/2024 was disposed of on 26/9/2024.
Yes, just wait, okay, just wait, yes. You're for respondent number
One.
1, 2.
One, I'm for one man,
Oh,
for the state,
you're for 1.
for the chief secretary.
No,
And
but the submission has to be made by the Home Commissioner, DGP. Deputy-
my lord, I'm coming to that. I'm for respondent number one.
Ah,
And since 6/6/2024,
ah,
my learned counsel, Mr. T.P. Jamir,
correct.
had been all along appearing on behalf of state respondent number 2 to 5.
Ah,
That is the Home Commissioner, TGP, Deputy Inspector General of Police,
correct.
and TGP of Civil Defense, Home Guards, Nagaland, Kohima.
2 to 5.
He is the main nodal department respondent. I'm for the chief secretary.
You have nothing to say in
I have
that.
nothing to say. I have no instructions. The main
Right, right.
respondent lies with the.
You could have told
respondent
that
number 2 to
before,
5.
at least, before we had
And
actually had a learned counsel for the appeal and our senior counsel, you could have at least met.
I'm listening, my lord. I'm listening.
When this court inquired whether you are ready with the hearing, you said yes.
However, prior to my submission, the learned counsel on behalf of respondent number 2 to 5.
Taking
Has-
cognizance of the submission made by the respondent number 2 to 5, we had actually we have actually sought inquiry from you.
I said,
Whether you are ready for hearing, you said yes. We were under the impression that you will submit.
since
on
the
behalf of the
junior for 2 to 5 respondents are trying to rely on my submission, I said,
You have no submission, what will they rely? And will it not be injustice to respondent number 2 to 5?
my lord,
If you don't have any submission and we record that
I'm,
Mr. LT Sanktam has no submission and the learned
My
counsel for the
lords.
respondent number 2 to 5 is relying on the submission made by LT Sanktam, will it be justified?
no, my lord.
That is why at the first instance, we were asking from you
All
whether you are
along-
ready and you said yes.
All along, the counsel for the writ
This
appellant,
is
they
not
are
a- See, you are an. additional
projecting
AG.
about the state additional advocate general.
We don't
submission.
expect such kind of misconduct from you. Yes, so, madam, I am sorry, but if this is the case, then
Lordship, if my lordships will humbly permit me
Yes.
to make my submission. The opposite party has already, the appellants has already submitted.
Yes.
And let the matter be kept part heard and let it come up.
This court is sitting only for today. This court is sitting only for today. It will be difficult for us. Both madam and me, we have made an endeavor to hear the parties and dispose the case at least. And we were also emboldened by the submission made by Mr. L. Sanktam that he is ready to hear.
Then tomorrow, Lordship. Then tomorrow or this week, Lordship.
Tomorrow, not possible. Tomorrow, I think we are having a long interview.
Lordship, the opposite party's submission is all recorded in both the writ petitions. So Lordship, if it suffice, because it is based on the submission of the opposite parties.
You are submitting for the private respondents. And Mr. L.T. Sangdam representing the chief secretary has no submissions. He has no instructions. Now, whether that can
They
be the
have-
basis of submission made by respondent number 2 to 5.
Lordship, in the last judgment, in the impugned judgment order, their submission has also been
I'm
recorded.
sorry, madam, you take a chance next week. You take a chance next week. Yes, Mr. TB will be there next week.
Yes, your lordship.
He'll be there.
Yes, he will be there.
So we will.
My learned friend has also gone to attend one bereavement. One of his relatives expired.
And Mr. L.T. Sangtam, you are there next week.
After, I'll try my, I'll try my. best.
Not try. We have heard it at least.
Yes, my lord.
When he says that he's got nothing to submit,
That's
whether
why,
his presence is needed.
that
or
is,
not.
I was just about to push his submission further. I was about to tell him that if you are not there, let one of the government advocates appear.
Since all along,
Because 2 to 5 will be, the submission of 2 to 5 will be
since
vital.
all along, respondent number 2 to 5, counsel for so-and-so are shifting the responsibility on respondent number 1. So when he has signed authority and power since 6/6/2024, the hearing took place only on 26/9/2024. Much before the
the-
hearing was
Your,
taken up.
your respondent number 1, chief secretary and the department, your family disputes cannot be adjudicated by this court.
Yes, my lord. However,
Yes, your family disputes cannot
the
be
total
adjudicated by
departments
this court.
are from 2 to 5.
We are only concerned about the case,
Yes, ma'am.
whether actually the law has been followed.
Let it come up next week, my lord.
Okay?
Yes, my lord.
Okay, Mr. Jamia,
Lordship,
is it okay for you?
Lordship, no difficulty for me.
Mr. C.T. Jamia. Learned senior counsel assisted by
Aliba
Aliba
Ozukam.
Ozukam. Learned counsel for the appellant, Mr. L.T. Sanktam. Learned additional AG appears for the,
State respondent number 1.
no. Mr. L.T. Sanktam. Learned additional AG for the respondent number 1. Mr. Peter Soto. Learned counsel appearing on behalf of Mr. T.B. Jamia for the respondent number 2, 3, 4, and 5. And Mr. Zad Jimomi.
Miss,
I'm sorry. And MS Zad Jimomi, Learned counsel for the respondent number
6 to
6
20.
to
20, Lordship.
My lord. My brother.
Yes.
Movie's name may be reflected.
Mr. Ma'am, Mr. LT Sanctum, learned addition AG.
Along
uh,
with
And Mr. V. Jimomi.
We can, if you want.
Stop. The matter was heard to some extent. But due to the presence of Mr. T.B. Jamir, due to the absence of Mr.
Absence.
T.B. Jamir, the learned counsel for the respondent number 2 to 5, the matter could not be finally disposed. Leaves the case again on seven.
Yes, Lordship.
Will it be
Seven
okay
is-
for you?
Uh,
Will it be okay for you?
I will come to that, Lordship. 7, I have some preoccupation.
14?
Lordship.
Okay, listed again on 14/5/2025
As a fixed item, Lordship.
as a fixed item, as a fixed item. Yes.
Most of like.
For admission, item number 6.
Yes, what is this? State,
Lordship, here, the writ petitioner, he is a work charge fixed paid employee, your lordship. And he does not come under the policy of the government for regularization. However, with perversity, the learned single judge has directed the state to regularize his service, your lordship.
how long he has been serving?
Your lordship, he has served for 35 years.
35.
Yes, lordship, he has served for 35 years, but he is on fixed pay employee. And after his retirement, only he filed the writ petition, your lordship.
But madam, I think recently there is a judge.
No, so that for the Supreme Court, that keep the ground of law kept open, your lordship. So we are agitating on the basis of the law. When the law does not permit for regularization, no matter how much he served, becomes irrelevant, your lordship.
Okay, we listed for hearing.
Your lordship, I'll be filing my affidavit in the position, your lordship.
What affidavit, madam? This is
Your
appeal.
lordship.
Your petition, your reply, everything is part of the record.
Yes, your lordship.
Any important facts you would like to clarify by way of an affidavit?
Your lordship, there's a decision of the division bench of this
Okay,
honorable court,
okay.
your lordship, which
You
is still
bring-
holding the
you want
field,
to
your
bring
lordship.
all those facts on record.
Yes, your lordship.
Okay, 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 ma'am.
Lordship,
That is-
yes, notice may be issued, your lordship.
No notice issued.
No,
Any other parties besides the government?
no party, it's only the sole respondent, your lordship.
Sole respondent?
Yeah, and the AG, on the last occasion, yeah. AG
I'm
is
appearing on
appearing, yes,
behalf
your
of
lordship.
You are.
my
okay.
senior.
You have also received the copies?
Yes,
Of the
Your
petition?
Lordship, yes.
Had MS V. Socrates, learned additional AG for the appellant. MS V. Terry, learned counsel for the
Respondent number 1.
respondent number 1, and MS
P. Mohombeni Izung on behalf of
so
Rosia Shike.
learned counsel. Learned counsel for the respondent number 2. Issue notice returnable in 4 weeks' time. Since both the respondent number 1 and 2 are represented through their respective counsels, no formal notice need be issued. You have served the copies.
Yes, your lordship.
The copies of the appeal petition has also been served to the learned counsel for the respondent number 1 and 2. MS V. Anithere. submits that he may be allowed to file affidavit to place on record certain material facts. Prayer is allowed? Prayer is allowed. Listed accordingly.
Much obliged.
For admission, item number 7.
Your lordship, for 7 and 8 also, it's the same facts of the case, your lordship.
No,
Yes.
but you,
Both of them, your lordship. They are the respondents, your lordship.
ma'am, Sam.
Yes,
Same,
You're
lordship.
forgetting your case.
yes, your lordship.
You're forgetting your case.
Hmm.
I think you have not been paid fees for this case. Only for the first and second. Okay, same order.
Yes,
Correct,
in
same
lordship.
order.
Yes.
Ma'am?
Item 8 also,
Item 7 and 8.
yes.
Yes.
For orders, item number 20.
This.
On the supplementary process.
Yes. Lordship, here there is a delay of 118 days in filing the connected appeal. So lordship, I pray that notice may be issued. Your
This
lordship.
is coming up for the first time.
First time, your lordship.
Ma'am, you are appearing
For respondent number 63 and 64.
63 and 64. Pro forma.
Yes, your lordship,
Pro
pro forma respondents.
MSV Secretary. The learned counsel, the learned additional AG. For the applicant. Stop. The present application has been filed under section 5 of the Limitation Act 1963. Seeking for condonation of delay of 118 days in filing the connected writ petition. Issue notice to the respondents, returnable after 4 weeks. MS, your good name, please.
Asinla Longkumar.
Asinla Longkumar appears for the respondent number 63 and 64. Therefore, no formal notice need be issued to the said respondents. The learned additional AG shall however furnish the copies of the application to the learned counsel for the respondent number 63 and 64. When?
I've already served to her, your lordship.
Okay, okay.
Yes,
In the course of the day.
okay.
In the course. Insofar as the respondent number 1 to
62.
62 are concerned. The learned counsel, the learned additional AG shall take step for service of notice upon the said respondent by registered post with AD within a period of,
Lordship, 1 week.
10 days from. the
Okay, okay, lordship.
Okay.
Much obliged.
For orders, item number 21.
Lordship, here also there is a delay of 118 days in filing the connected appeal. It's
Same.
arising out of the common judgment or the same, but
Same,
the respondent,
118 days.
respondent is different. She is a respondent number 32 and 33.
32 and 33.
Yes.
32 and 33. Okay.
Yes,
So instead of that 60, so and so 32, 33, the rest same.
the rest 1 to 31 and 34,
1 to
lordship.
31, 34
Yes.
by registered post with AD within a period of 10 days.
10 days,
Okay,
lordship.
ma'am?
Much obliged.
Yes.
For hearing, item number 13.
Mr. You're for 13.
Yes, my lord.
Yes.
Yes, your lordship. I'm appealing for NIA, but I'm seeking, sir, adjournment in this case, your lordship. I'm away from my office, sir.
You are for NIA.
NIA, sir, NIA.
NIA.
Sir,
You are Mr.
Lokesh Kumar, sir, PPNIA.
Lokesh Kumar. But here NIA is NN Mishra.
He was earlier public prosecutor, sir. I joined
You have
last
taken
year.
over. You have taken over.
Yes, sir. Yes, sir.
Okay, you are Mr. Lokesh Kumar.
Lokesh Kumar, sir.
How much adjournment? For how many days?
For 4 weeks, sir.
4 weeks. Okay. 4 weeks, they are seeking adjournment. Whether your person is on bail.
Yes, on bail, my
Sir,
lord.
sir, he's on bail.
Mr. Lokesh Kumar, the learned counsel,
Learn PB.
Leonard,
if you-
maybe for the NIA, 6 adjournment of the case for 4 weeks. The counsel for the other side has no objection, listed accordingly. Okay? Yes,
Hello,
Wait.
over. Yeah, over.